This is Alex Berger with Lawyer Up Berger Law, and today I'm going to talk about a recent trial that we had, and specifically I'm going to dig into how we addressed the standardized field sobriety test with the jury in that case, because it was an interesting strategy that we deployed. The standardized field sobriety tests are standardized by the National Highway Traffic Safety Administration, and this has the benefit that all officers, if they are trained in standardized field sobriety tests, they all underwent the same training. I've underwent the same training. Associate of mine has gone to the training. So we all kind of have this base knowledge, and we all operate from the same manual and text for how standardized field sobriety tests are supposed to be done. So in this case, it was the same thing. It was an officer that conducted standardized field sobriety tests. My client supposedly failed them. That is, she showed enough signs of impairment for them to tell the officer that my client was impaired. But the laboratory results of her blood analysis came back below the legal threshold for alcohol. So we had to deal with, primarily at trial, these standardized field sobriety tests that supposedly said she was impaired. And the way that we dealt with this was by digging into the standardized field sobriety test training. I've done many impaired driving trials. I've cross-examined a lot of officers about these standardized field sobriety tests. And there are these statistics that the officers, the well-trained and well-read officers, say about how good the tests are for alcohol. So the National Highway Traffic Safety Administration, the Field Sobriety Test Manual, has this whole section on the validation. That is, the studies that show that these field sobriety tests actually show impairment. Now, I could talk about those studies for hours, and I've been to several seminars where they break them apart. They are not peer-reviewed, scientific, double-blind studies. They are just basically studies done by law enforcement or by the National Highway Traffic Safety Administration through law enforcement. But basically, their best study that they have is this 1998 San Diego study, where they had officers actually go out and do the field sobriety tests, and then they checked to see how frequently each of them were accurate, and they were accurate together. So what the 1998 San Diego test showed, according to the field sobriety test manual at least, is that on the horizontal gaze nystagmus, that's the first eye test, the first of the 3 field sobriety tests, if someone showed 4 or more clues of impairment, then there was an 88% chance that their blood alcohol content was above a 0.08, which is the legal threshold. On the second field sobriety test, the walk and turn test, if someone showed at least 2 validated clues of impairment on that, there was an 83% chance that that person's blood alcohol content was above a 0.08. And on the final and third field sobriety test, the one-leg stand, the San Diego study said there's a 79% chance, if the person shows at least 2 clues of impairment, that that person is above a 0.08. And taken all together, based on the San Diego study, if an individual suspect failed, that is, showed enough clues on all 3 standardized field sobriety tests, according to that study, it was a 91% chance that that individual was above a 0.08. So, I've had officers tell me the 88% on the eye test. I've had officers tell me the 91% on all tests overall if my client failed it. And generally, these statistics are irritating to me as a defense attorney because, number one, I think they're just pulled out of thin air, more or less. I don't think these tests are rigorous enough to give these percentages. And also, they sound good, but they're really not that high. Like, we're going to convict an innocent person when 9 out of 100 times they might not be guilty. That's not acceptable in our criminal justice system. But anyway, the officers like these stats. So I turned those stats on their head for this trial. I went through with the officer each of the tests, each of the clues, and had her confirm that on the eye test, it was an 88% chance that my client was above a 0.08. so on and so forth, and that in this case, according to her training, there was a 91% chance that my client's blood alcohol content was above a 0.08. She agreed with all of that because it is in the manual published by the federal agency for training these field sobriety tests in officers. So then I took her confirmation that there's a 91% chance that my client's blood alcohol content was above a 0.08. And then for the jury, I said the blood alcohol content was not above a 0.08. Therefore, the tests themselves failed here. My client was in the 9% that are false positives because she should have been above a 0.08, 91% chance, if they'd worked. So I told the jury, we're here on beyond a reasonable doubt. You have to believe my client was impaired beyond a reasonable doubt. These tests failed to show what they were supposed to show, so you should just disregard the tests. Um, and the jury understood it and accepted it. It was a very quick not guilty verdict. But I think there are two things here. Number one, it's using their own faulty statistics against their prosecutions for these field sobriety tests, which I think is a good way to show that they don't work. But secondly, it just made the tests absurd. I mean, the jury was able to watch these tests, and my client did not appear impaired at all. But based on the clues that they're looking for, my client showed impaired. So the jury had to look at my client and decide whether or not she was impaired. She was not. This was the right verdict here. But it showed that the tests themselves have flaws, and it pointed out using their own statistics. This strategy will only work in a case where the blood alcohol content comes below a 0.08, and that really, in those situations, the case should be dismissed. In this case, the prosecutor elected to bring it to trial. But I just wanted to share that kind of nitty-gritty analysis of how we use the Standardized Field Sobriety Test manual and the statistics in that to get a not guilty verdict for our client.